Hello everyone. This week we're looking at the concept of justice as rules. Now last week we started to introduce the ways in which law sees justice, and this is one of the primary ways, and this is probably one of the most familiar ways of thinking about justice across many different societies, and that is a set of rules, usually prohibitions. Rules don't work very well in terms of requiring behaviour. They tend to be better at preventing behaviour, but it tends to be a list of things that you can't do with attached punishments. It is actually quite difficult to provide systems that provide rewards for good behaviour, or that force people into certain forms of behaviour, as we saw during the pandemic, that even where things are in people's own interest, they very much resist rules that say you must do this and you must do that. So generally rules are written in a negative form. It is prohibited to do this, this and this, and they are written in a way that's simplified, using language that's designed to apply to as many different situations as possible. And rules are generally forward-looking. From this point onwards, you are not allowed to do this. If you do this and you get caught, this will be the punishment for doing that. Now we're going to look at different conceptions of rules, different conceptions of justice over the next few weeks, and we'll see a stark contrast next week when we look at precedents, which are generally backward looking. They're looking at what's happened in the past and looking at making decisions consistent with those principles of what's happened in the past. So we've got and the theorist Julia Black talks about a conversation. Other people have talked about a dance between these two different ways of affording justice. One in terms of agreeing on a set of rules, and the other on following what we've done in the past in terms of consistency. And then the following 2 weeks we'll look at some other ideas of justice in terms of stories and in terms of bureaucratic procedures. But this week we're really focusing on that idea of setting rules, and this is primarily in our system what's done through the legislature, and most pieces of legislation take that format of a list of rules, and we'll look at a little bit more detail of legislation in just a moment. But this is of course not the only form of rules we have in society. We do have rules everywhere. Games and sports all have rules. We have rules that are formal or informal. There are rules about which side of the escalator you stand on so that people can pass you if they're in a hurry in an escalator. And you know, people who don't follow those rules get a whole lot of social disapprobation from everyone else, but they don't necessarily, there's no formal rules in place that say you have to stand on one side of the escalator so that people can, you know, who are hurrying can take the fast lane up. So I guess what I want to do is contextualize this idea of rules within our broader social framework of rules following, that legislations and formal laws are only one part of that. And of course, when we talked last week about regulations and how regulations are different from legislation, primarily because they don't go through Parliament, that there's power delegated to an authority to make those rules. Same thing though, it tends to be, you know, the legislation is passed that says, you know, the dog catcher shall have the power to make rules around catching dogs, and then the dog catcher then is empowered to be able to, as an executive body, make those rules without going back to Parliament. But we'll come back to that distinction between legislation and regulation again later on. I just wanted to touch on it here. Our rules are probably one of the earliest techniques of governance that we've had socially, and a lot of anthropologists have compared different societies in terms of the notions of taboos. So our earliest forms of rulemaking were vested in spiritual and religious beliefs, and they tended to be around things that were forbidden. And there's a strand of thought, I guess a school within anthropology that we call structural anthropology, and they were big on this idea that all societies share certain things in common, and they looked at that rules against things like murder, rules against things like incest, rules against cannibalism were common across pretty much every culture. So they said they saw rule making as really embedded in this structural part of society that, with a few small exceptions, were consistent across all cultures. As I said, those tended to be originally vested within spiritual beliefs rather than rational beliefs. There's a strong taboo against cannibalism before we even knew what a prion was, or what the prion, what prion disease would do to someone. And if you don't know, look up prions. It's disgusting. Similarly, rules against things like incest had very strong cultural foundations, may indeed even have biological foundations. There's certain research that suggests that there is a kind of biological regulation on incest. But nevertheless, most societies have pretty strict rules around incest. Later on, we've learnt pragmatic reasons for those things, but often the spiritual religious foundations remain. And I mean, I guess looking at food taboos, looking at kosher rules, and looking at halal rules and those sort of things is another example of the rules tend to have come from a very sensible place in terms of preventing people getting sick from food that's been prepared or stored the wrong way. And yet today they persist, and they still have the religious foundation supporting them, even though we also know that there are strong scientific and rational reasons as well. So rules are quite complex, and they can still, they persist across multiple domains. Now, I don't want to go too much into anthropology, but I do want to just flag that there is another school of thought, which are the post-structuralists, who are quite critical of what the structuralists said. Like any academic school, you end up with different warring factions and things. So just, acknowledging that structuralism isn't the only way of understanding how societies work. But it's, for our purposes, I think it lays down a really useful foundation for why do we have rules? Why do we follow? Why do we establish these things? And to look at that fundamental social reality of why some of these rules have emerged and are maintained over time. All right, so how does contemporary law deal with rules? Well, we have legislation, which is created by Parliament. Some parliaments have two houses. They have a lower house and an upper house. Some, like Queensland, I believe still has just one house. The federal government, the Commonwealth government, has the House of Representatives and the Senate, with the idea that these are checks and balances on misuse of power. In the Australian Commonwealth context, this was done because the Senate, it was just designed to protect states' interests. And when Australia was federated, there was a certain concern that the most populous states would end up with the most representatives in the House of Reps, and that they would then be able to run roughshod over the states with smaller populations. So the Senate was there so that you had to have approval of both the majority of representation on the representatives on the basis of, number of people, and then there was a representation on the basis of the number of states to protect states' interests. So a lot of our legal structures, whether or not they work, that's a much bigger conversation in terms of how effective they are. But they're there not just arbitrarily, but they're there as checks and balances on the use of power in an arbitrary way to assert the democratic process. Okay, what's next? The next thing I guess that it's important for you folks to do is to have a look at a piece of legislation. Now, I'm not saying read an entire act, but I'm suggesting that it's worth just scanning through some legislation just to understand its structure, the way in which it's organised, and the sort of language that's used, because there's a whole tradition around what works as regulatory language and what works as defining rules, because there is really a sweet spot between defining a rule specific enough that people will agree on it, but not so specific that you don't have any wiggle room for its application. So our whole history of lawmaking has been that balance between those two things of not having a law that's too general but not too specific. And an example of that, I guess, is the development of traffic laws. This is a reasonably modern thing because we've only had dangerous motor vehicles for a reasonably short period in our history. And the earliest of ways of regulating traffic was just to use the other existing areas of law. So if you ran someone over, we deferred over just the general criminal law. Would that be a form of assault? Would it be grievous bodily harm? Would it be manslaughter or even murder if you did it with intent? So we tended to use those existing areas of law. But soon we decided that we needed more specific nuance around traffic laws. So we invented laws, criminal laws, such as dangerous driving. And that tends to be a very blanket kind of law that says if you drive dangerously, this is the penalty. It might provide some examples of what's considered dangerous, but it then I think it's an example of a law that was difficult to apply because it was too broad, and juries were a little bit reluctant to convict in some cases when someone, for instance, was speeding. It was what does going too fast means? Because remember, this is before we had speeding laws and speed limits. How fast would someone have to be going before you said they were driving dangerously? How drunk would they have to be before you said they were driving dangerously? What evidence would you have to use to show that they were driving dangerously? So that's why we then created a whole series of other laws that were more specific. So we created speed limits. We created this rule that deemed if you were driving faster than a certain speed, you were automatically considered to be driving dangerously. You were breaking the law just because you were breaking the speed limit, not because there was any evidence that what you were doing was dangerous. So that becomes a law that's easier to apply, because if you've got the evidence that someone is driving 20 kilometres over the speed limit, then that's pretty much a done deal, unless you ask a physicist, because a lot of physicists will tell you all the problems with radar guns and how inaccurate they are. But let's just leave that aside for the moment. And the same with drink driving. We've deemed a certain amount of blood alcohol level to be dangerous, no matter what impact it actually has on your driving. And my old criminal law lecturer was always proud of saying that he could drive better drunk than most people could drive sober. I'm not quite sure what the message of that was for his students. But anyway, I'm just getting across the fact that the things you can regulate, and it's something that I call the regulatory nexus, it's a thing you attach rules to, can take different forms. And you then have a series of other rules that come into play to support those rules. So in Australia, for instance, because we want to regulate drink driving, and we want to do it in a way that is proactive rather than reactive, rather than someone runs someone over and then we blood test them and see if they were drunk or not. We want to be able to act in a preventative way. We have laws that surround random breath testing. Interestingly enough, many states in America, that's considered unconstitutional. It's considered to breach the due process provisions of the American Constitution. So this is why you see stuff in movies where they make people walk in a straight line and touch their nose and whatever else, because when they stop someone, they need to have a reason to breath test them. So they have to observe other behaviour that indicates that they might be drunk before they have cause to administer the breath test. In Australia, we don't have that sort of protection under our constitution, or that kind of right under our constitution. So there hasn't ever been a problem with random breath testing. But, with a lot of these things, it then becomes a series of, to what extent do we erode liberties to create rules that support other sets of rules? And we're going to come back to this in a couple of weeks' time when we look at the rise of regulation and the way in which regulations is a concept of regulatory creep. Once you start regulating something, it just sort of starts creeping out further and further. So, our random breath testing laws are really a way of supporting laws to protect life, liberty, and so on. They're to protect people from being killed or injured on the road, and to a certain extent having their property damaged on the road. But we do that through a series of other steps. We do it through a series of looking at, introducing, one of the first things we introduced was vehicular manslaughter laws in various forms, because juries were very reluctant to convict people on the basis of manslaughter. So we basically introduced laws that were the same as manslaughter but using a car, in which case juries were much more confident in convicting. And, just to fill in, manslaughter is unlawful killing of someone without intent. Murder is unlawful killing with intent. Manslaughter is without that intent. So some of the innovations we have, the changes we have around systems of law, come about because of the difficulties of administering them, difficulties of policing, and the difficulties of getting convictions with juries in many cases. All right, so we start off with this, original criminal law about protecting people from unlawful death, unlawful injury. And we move through these series of different laws around dangerous driving, whatever. And at the end of the day, we end up with laws that give power to police to randomly stop people without cause and breath test them as a preventative measure. So I hope you can see how you've got this continuum of complexity in laws and specificity. At the one end, we've got these very broad laws that say it's unlawful to kill someone, it's unlawful to injure someone, and at the other end, we've got a law that says it's unlawful to refuse to grant a breath sample at a random breath stop, and it's to try and achieve that end without the complexities in between. Anyway, getting back to the point I was making, this is a good time for you to have a look at a piece of legislation. Legislation tends to be on parliamentary websites. Also, the AustLII website, which we talk about again next module, is a big repository of all the laws of Australia that's free and open to everyone. So you can access laws in different ways. And I just want you to have a bit of a look to get some familiarity. And these sites will have an index of the different types of laws. So pick something you're interested in. Don't pick the Mortgage Adjustment Rebatement Fees Act, Amendment Act, if you're not absolutely interested in that stuff. But if you're interested in animals, have a look for Animals Act. Look for Livestock Act, and look at see the types of regulations that are there. The topic doesn't really matter. The state and federal constitutions are probably worth a look too, but it's just at this point to have a look at the way systems of rules are expressed in these written documents. And one of the first things that is interesting is that they're organised by numbered sections that allow you to refer back and forth. And if you've ever done any basic programming, it's pretty much like basic programming code, where you have line numbers. You have section 1, section 2, section 3, which means that, in section 47, subsection 1, you can refer back to, the list of elements in section 3, and it provides a way of navigating legislation. So that's probably the first thing to note, is they're these little almost like software code engines where you use line numbers to navigate your way through. So things to look out for in a piece of legislation. First of all, right at the beginning, there'll be a purpose. That's interesting, and that's going to be something that helps courts, if they have to interpret whether a rule or not applies, they can use that to help them understand those borderline cases. There are definition sections, and that's so you don't have to define a concept every time you use it. So if you're using the Weapons Act and you say a weapon includes this, this, and this, then throughout the rest of the Act you can use the word weapon and refer back to the definition section without having to restate that every time. Then there are active elements of a piece of legislation. I'm using the words legislation and act and statute. They're all interchangeable. Why we have three different words for it, I don't know. But these aren't defined as active sections. It doesn't say this is an active section, but you'll see that there are sections of an act which do something, that actually proclaim a rule or confer power. We'll come back to the power thing in a moment, but a rule that says, no running by the pool actually proclaims this is the rule. And they will often, the next thing we go into is penalties and benefits. They'll say the penalty for breaking that rule is such and such. And one thing you will notice when you look at these statutes is that there's comparatively little that's active. Usually there's a small part of an act that's just like, here are the rules. And there's a whole lot of stuff that follows on about how it's to be implemented and how it's to be administered. And that's interesting because you don't get that so much. I was going to say you don't get so much in sport, but in professional sports, and you're getting that increasingly, and you're increasingly having the game, and then you're having the tribunal afterwards, where everyone's challenging particular behaviour and interpretations of the rules. So sports are becoming increasingly sort of legalistic. But yeah, we tend to expect that the Animals Act will all be talking about rules about animals, and what we'll find is there's a little bit that has the rules, and then there's a lot of stuff about how we actually implement those. So the next thing is the transfer of power. So that will often create an authority and say, Parliament will create the Animals Registration Authority, and this is their powers, and this is what they can do, and this is how the Act will create it. Or it'll transfer power to an existing body. So the Weapons Act will say the police are able to administer, these provisions, the provisions under this Act. So there's a lot of stuff that has to be done in terms of that admin heavy lifting. It tends to be quite boring, and for students sort of in the justice level, they're pretty safe to skip. Law students have to be a little bit more worried about it, because if a legal controversy occurs, if a legal conflict occurs, one of the things you have to do as a lawyer is make sure that the people who had the power were properly assigned that power and all that kind of stuff. But for the rest of us who don't have to do that, that stuff is generally pretty skippable. And there's an awful lot of that stuff in a lot of legislation. You'll also see delegations, and that's where there is the ability to create extra sets of rules. And then this is again what we talk about later in terms of regulation, where non-representative bodies are given express power to make further rules, but the legislation will be specific about what the limits of those are. It doesn't just say, and we give the dog catcher power to do whatever they want. It'll say something like the dog catcher will have power to, set penalties, or to decide on what breeds of dog are considered dangerous dogs, or those sort of things. So it'll allow them to make their own rules, but it gives them really strict guidelines as to how they can do that. And again, that's a whole new area of law. When the dog catcher has the power to go and catch dogs and make rules around dogs, and the dog catcher starts catching cats and says, well, they're basically the same thing as dogs. And then we've got a whole legal controversy over, whether they're following that power and the way it's delegated. And the final thing to note is amendments. One of the things about legislation that makes it work as a little regulatory machine is the ability for Parliament to come back later on and just amend part of an act, and to come along and to maybe insert another section, or to change a word or a phrase, or and that's when we have the Weapons Act 1985, we have the Weapons Act Amendment Act 1990, and those later acts amend the earlier acts and the text in them. The good news for you folk is, in the electronic age, the online versions of acts are always kept up to date, have a little sympathy for people in the bad old days, like when I was learning, where you basically had to look up all the amending acts and amend your own legislation because everything was in print and you didn't have electronic versions, and you had to go in and cut and paste bits from the amending acts into the new acts. So, you know, that's one great thing about technology. So, but it does mean that sometimes there may be an event that happened in the past, and then you get an amending act, and the amending act only amends from that point onwards, and the act happened before the amendments, and there's all this. Again, this is complex stuff that lawyers deal with that most people don't really have to deal with, but I just wanted to raise it as one of those features of legislation for thinking that if we see the act as it is online, there's a whole history in terms of the way in which it was amended over time, and that will tend to be indicated in the act itself, but that might be something you see. Now, the last thing I wanted to mention today, actually there's two more things I want to mention. The first is the rules for interpreting rules. And these are started out as conventions that courts used in interpreting rule systems. They've since been embedded in legislation. So you actually have the Acts Interpretation Act, which is an act to interpret acts. And it also interprets the Acts Interpretation Act. So you get a bit of a recursive loop around interpretation. But these are the three basic rules in terms of what happens when you have a conflict of opinion as to the way in which a rule applies. So this is about legal interpretation, but I also want to broaden that idea and think about how it applies to other rules, like just, you know, the rules of the pool, no running by the pool, or rules that a family might set. So these are the three sort of meta rules. The first is the golden rule. And the golden rule is you should always follow the literal meaning of the words. So if the words are certain, then you can't say, well, you know, if you look at it a different way, this word might mean this. And I think this is one of the misapprehensions a lot of people have about law, is that all that lawyers do is get in and find an ordinary word and say, oh, if you look at it in this way, this word is, you know, can mean all sorts of different things. The golden rule is you always go with the literal meaning of the words, unless the application of that rule would be manifestly absurd. So there's a whole lot of rules, sub-rules about what manifest absurdity means. Of course there are. But it means more than just being ambiguous. It means that there's something really wrong with the way in which a rule is applied before we can actually circumvent the golden rule. So I think that's a good starting point, and it's a good fact that most rules that we have a pretty common English language meaning, and most of the time we just follow that as it is. Okay, so the next rule is, I guess, a subset of that rule, which is the literal rule, which is if there is any doubt, if there is any ambiguity, always follow the literal meaning. So that kind of follows on the same thing. I mean, the golden rule says that, you know, there's got to be a really something stronger than ambiguity before we actually analyze it. The literal rule says that if in doubt, just go with what the words say. The premise of that is everyone has been following the words as written, and, you know, if we start messing around with that, then when we make a very uncertain system. You know, if we say no running by the pool, and we start saying, oh yeah, but what does running mean? And we start digging into semantics about what's running is. Well, everyone's been following the no running by the pool rule, and we suddenly create a whole lot of uncertainty once we start saying, unless we have a really good reason to defy that. And that's where the third rule comes in, which is the purpose rule, or I prefer the old-fashioned phrase, which was the mischief rule. Just because, you know, law has these wonderfully quaint ways of putting things. But the purpose rule says if there's an absurd result, you can try and find out what the purpose of the law is by looking at what the intention of Parliament was. And this is where things like the purpose section in an act, we can go back to that. We can look at speeches in Parliament, and we can look at a limited number of other contextual things to try and see what the meaning of the original intention was. Now, I'm going to give you an example, a really often used example, so this will make a bit more sense to you. America has, under the amendments to its Constitution, a right to bear arms. I'm not going to go through the specific words of it here, but it basically, the question is what, it's not usually what bear is, it's usually the question is about is what is arms. And in the modern day, I mean, that law was created when people used muskets. And maybe a cannon was, you could have a cannon, but I don't know if they intended you to be able to drag a cannon around with you. Now, because that's in the American Constitution, you can't modify that by local laws. The Constitution always overrides those laws. So the golden rule is there any ambiguity in the right to bear arms? Well, maybe there is, because technological change has meant there's a whole lot of different things that theoretically count as arms. We've got all sorts of automatic weapons, we've got assault weapons and everything else. Flamethrowers, missile launchers, do those things count as arms? Well, we go to the literal rule first. So the golden rule says, is there any ambiguity? Is there a significant ambiguity? Probably yes. Someone using, carrying a missile launcher around with them is probably it seems to be an absurd result, okay, that people then can all carry around these heavy weapons. And assault weapons are, of course, the most contentious one today. So the literal rule, we look at that and we say, when in doubt, follow the literal meaning of the words. Well, the literal meaning of the words arms is really broad. It can include a whole lot of things. So the literal rule doesn't necessarily help us regulate weapons. And this is the argument that is generally used by pro-gun people as well. The law, it's clear. It says you have the right to bear arms. The end of story. Now, if you decide that result is still absurd, that someone carrying around their assault rifle is still absurd under the law, you can go to the purpose or mischief rule, which means you go back to the intentions of the founding fathers. There's a whole lot of debates, there's a whole lot of things that were written about what the right to bear arms actually meant. And unfortunately, that still hasn't resolved the dispute legally, because there are so many different ways people have interpreted what the founding fathers have said. So it's just opened up for more in the US for more debate. There's a similar right in the English Bill of Rights, which is not a constitution. It's just an ordinary piece of law. But basically, that right in the English version is the right for Protestants to carry weapons in order to kill Catholics. Because the law was created around the time of the religious wars in England. So it was if you look at the original legislative intent, under the English law, it's really all about the destruction of Catholicism and using militia to kill Catholics. So that's not a law that has general application now. And of course has been overridden by various criminal laws about weapons, because it's not constitutionally protected. But anyway, I think that's an example, and of course we don't have any similar rights as in Australia, so it's not an issue. But I think that's hopefully given an example to you of, most of the time we don't dig into the history of a law, but if there is significant, we talk about manifest absurdity, but if we can raise that contentiousness over a law that's historical, we can start going back into those details. All right, I've gone on quite a long time today. The other thing I wanted to quickly mention that's in the readings is that, how do we determine law, overall, whether or not laws are working? There are different global bodies that oversee the legal stability of different jurisdictions, different countries, different regimes, and I've referred to some of those there. Most interesting for us, I think, is the Sustainable Development Goals of the UN, where there is a goal to to secure peace, justice, and strong institutions. And there's been research there across the globe as to the way in which the legal regulatory systems of different countries can be evaluated and compared. So I didn't want to spend a lot of time on that, but I thought it was useful for you guys to know, particularly if you're in a position where you're looking at a series of laws that seem unfair or unjust, getting back to our core theme of justice, that there is a level of analysis across different countries, often based out of the UN, that reviews these things.